This is Bloomberg Law with June Grasso from Bloomberg Radio.
There were demonstrations in more than a dozen major cities across the country this week over the Trump administration's immigration crackdown as ICE conducts high-profile workplace raids. In response to the protests in Los Angeles, President Trump deployed thousands of guard troops and hundreds of active-duty Marines to the city without the request of the state's governor.
If we weren't there, if we didn't bring in the National Guard and the Marines, you would probably have a city that was burning to the ground, just like it was a number of months ago with the housing.
But California took Trump to court, saying his choice to deploy the National Guard to police civilian communities is an expansive, dangerous conception of federal executive power. And on Thursday, federal judge Charles Breyer found that Trump's actions were illegal and that the L.A. protests fell far short of the legal requirements of a rebellion needed to justify a federal deployment. He ordered Trump to return command of the Guardsmen to California Governor Gavin Newsom.
He must work under the constraints as a constitutional officer of the Constitution of the United States of America. That's what this court order demands of the President of the United States. He is not a monarch, he is not a king, and he should stop acting like one.
But just a few hours later, a federal appeals court temporarily blocked the judge's order, saying it will hold a hearing on the matter on Tuesday. Joining me is immigration law expert Leon Fresco, a partner at Holland Knight, and the former head of the Office of Immigration Litigation in the Obama administration. Leon, Judge Charles Breyer, who, by the way, is Justice Stephen Breyer's brother, wrote this scathing opinion, finding that the president acted illegally in deploying the troops, exceeding both his statutory authority and violating the 10th Amendment. Tell us how he came to that conclusion.
So there's a couple of things. The first was that President Trump said that he had authority under 10 U.S.C. Section 12406, which provides that the president can call federal service members and units of the National Guard of any state when the United States is either invaded or is in danger of invasion, or there's a rebellion or in danger of rebellion, or most notably that the president is unable with the regular forces to execute the laws of the United States. And so that was the real argument that was being made there. And what Judge Breyer really tried to get a grip on and tried to figure out was, there's two questions here. One, did you violate that statute because there really wasn't any type of rebellion or an inability to enforce the law? But second, is there some inherent authority that the president has that makes these kinds of questions unreviewable? Because even if this was a dispute about the rebellion or not, the Trump administration was saying, this is our decision. This is committed to our discretion. It's not for the courts to review this. And so this is where Judge Breyer said two different points. One, on the statute, there was no consultation with the governor, which is required under the statute. Congress wrote that there had to be meaningful consultation with the governor before taking over the state's National Guard. And secondly, there wasn't this rebellion or invasion or inability to enforce the law. So nothing justified the federalization of the National Guard. And this is the kind of determination that can be reviewed. And if you can't review this determination, then there is no check of any kind on the president being able to deploy the National Guard for any purpose at any time for any reason. And that's what really was animating a lot of his concerns in the ruling during the oral argument. And I think that's going to be really the main question that is grappled with both by the Ninth Circuit and by the Supreme Court ultimately, this question of, is this really unreviewable? And if it's unreviewable, what does that mean moving forward for giving the president authority to mobilize federal troops whenever the president sees fit?
So we've talked before about the courts deferring to the president's decisions on foreign policy and national security. But Judge Breyer said this case involves domestic use of military force, on which the courts can certainly weigh in. Is that the line that he found?
Correct. The limiting principle that at the end of the day led the judge to believe this is reviewable is the fact that if this was something that in some way implicated foreign policy or the use of the military to deter an actual foreign invasion happening, that might be something where the courts have no role. But here, the fact that the fact pattern was in all four corners limited to a domestic dispute, that led the judge to say, in this instance where you have a federal military action in a domestic dispute, the courts have to have an ability to analyze this and to be able to have some constraints on presidential authority. Otherwise, if it were to be committed to a discretion of the president, would mean that the president could just employ these federal troops at any time for any purpose. And he viewed that as unacceptable under the Constitution. Now, I think the Trump administration would make some arguments, which they've done, in that the influx of foreign nationals is itself an invasion. But the courts, other than one judge in one of the cases in Pennsylvania, the courts so far have not actually characterized the influx of foreign nationals during the Biden administration as an actual invasion, in the sense that the folks that entered are there to overthrow the government of the United States.
Just within hours of Breyer's decision, the Trump administration went to the Ninth Circuit, and a panel of judges consisting of 2 Trump appointees and 1 Biden appointee put Judge Breyer's decision on hold, and they're going to have a hearing on Tuesday. Why do you think the Ninth Circuit did that when Judge Breyer had found irreparable harm to the city and that the presence of troops in L.A. was itself inflaming tensions with protesters?
Well, there was an administrative stay put until Friday for the district court, and so all that was really done by the Ninth Circuit, and this was a unanimous decision to the extent that it's a one-page decision, but nevertheless, there wasn't a dissent from this administrative stay, is they just basically held this in abeyance to have a hearing on Tuesday, and then they might make a decision shortly thereafter. But I do think there is probably some view of the events going on in the world right now and some desire to maybe keep the status quo for the weekend, just in case, with all the conflagrations going on everywhere. It might not necessarily be a good thing to be having civil unrest in Los Angeles. So I think there might be some prudential consideration there in keeping the stay over the weekend. But, you know, hard to read minds, but I think that probably is underlying some of this.
There are concerns that President Trump might send troops to other cities because his June 7th proclamation is broad and allows troops to be sent anywhere protests are likely to occur. Will Judge Breyer's order, if upheld on appeal, have any impact?
So the order itself certainly provides a precedent for other states and other cities to actually look at this order and say 2 things. One, that there is court jurisdiction in order to review this, and I think that's going to be the key argument to the extent that this gets to the Supreme Court, is forget about interpreting the statutes. Is there actually jurisdiction to interpret the statute? And then once you start getting to interpreting the statute, then the administration is in a bit of a more difficult pickle here, because then you have to decide, is there a rebellion? Is there an invasion? Is there an inability to enforce the law? And there, at the moment, the factual record on that is not as fulsome for the administration as they might want going into court. And so they would definitely need more than what happened in Los Angeles to be able to deploy the National Guard and the military, especially to enforce ICE operations. But they might not need anything at all if the Supreme Court ends up saying that this isn't something that's reviewable. But I think every court's going to have the same struggle that Judge Breyer had, which is it makes sense in one sense to defer to the administration because these are very serious questions. These are very difficult issues. But if you have complete deference what is to stop a very arbitrary and capricious application of this for pretty much any reason. And so that's where this gets complicated.
The last time a president activated a state's National Guard without a request from the governor was in 1965 when President Lyndon Johnson used the Guard to protect civil rights demonstrators in Alabama after the governor refused to do so. Some are pointing to that as precedent for Trump's actions here.
Well, I think the problem is there. You would say the same thing, which was there was an inability to enforce the federal law. The states did not want to enforce the federal law. And so you needed to actually have the National Guard there to enforce the federal law. Here, there is an assertion that the states are not enforcing the federal law. But the problem is in these immigration contexts, the states don't enforce the federal law. They're not supposed to round people up and deport them. So that's just for the federal government to do. Now, if the state police was actually blocking the ability to find people for deportation, I think the president would be in a much stronger ground here. But they would need that sort of evidence to be presenting to court in this context, which is here we are just trying to have ICE agents enforce the law, and we're encountering actual resistance from state and local officials to our ability to do this, as opposed to verbal, hey, don't do this, which is, most of what you see. If there was actual impediment and roadblocks, then I do think this argument would be much stronger on the administration's part.
Stay with me, Leon. Coming up next, I'll continue this conversation with Leon Fresco. We'll discuss why Senator Alex Padilla of California was forcibly removed from the Homeland Security Secretary's press conference and handcuffed. I'm June Grasso, and you're listening to Bloomberg. This week, President Trump ordered the deployment of about 4,000 National Guard troops and 700 Marines to Los Angeles, following protests that have been concentrated in a few blocks downtown over his stepped-up enforcement of immigration laws. And on Thursday, as lawyers for the state and the federal government were arguing in L.A. federal court about whether the president had overstepped his authority by deploying the National Guard without the governor's request, in the federal building, the senior U.S. Senator from California, Alex Padilla, was forcibly removed from the press conference of Homeland Security Secretary Kristi Noem as he interrupted her to try to ask a question.
I have a question for the Secretary.
I also want to talk about...
The senator was pushed from the room by FBI agents and Secret Service, who then forced him to the ground in the hallway outside and handcuffed him.
If this is how the Department of Homeland Security responds to a senator with a question, you can only imagine what they're doing to farm workers, to cooks, to day laborers.
I've been talking to immigration law expert Leon Fresco, a partner at Holland Knight. Leon, let's put this incident with Senator Padilla in context. In the last 2 months, there have been arrests of a Wisconsin judge, a New Jersey congresswoman, and a California union leader, all with regard to immigration issues. And the border czar, Tom Homan, has even threatened to arrest the governor of California for obstructing immigration enforcement. And the president said that would be great. And now we have this handcuffing of a U.S. senator. Is this an attempt to try to intimidate officials, to warn them about interfering with the ICE crackdown?
Well, I think there's a bunch of points that all have to be separated factually and contextually. There is on one side of the spectrum a scenario whereby ICE is in the middle of an operation and there's some official who does something that makes it so that that operation is not successful. So if you had the judge who escorts the person that ICE is looking for outside of a different door so that ICE can't find them, you can say that that's harboring or concealing, because that statute is very broad, and pretty much any assistance like that that you give to someone who you know is in the country illegally, you are violating the statute. So that's one scenario. Then you have the other scenario, the two things that have happened, one with the congresswoman from New Jersey in the detention facility, and now Senator Padilla. These are very complicated because we don't have anybody with clean hands, in the sense of, you have in the video Senator Padilla coming into this press conference. You have Secretary Noem speaking, and he's speaking over her, and he's walking toward her direction and is speaking over her. It's not like he waits till there's a pause to ask a question. He's verbally interrupting her press conference. But then you have that dealt with in a manner where it's not just that he's taken out of the room and the door is closed, let's say, but he's taken out of the room, he's put to the floor, and he's handcuffed. And so there's the argument there about excessive force and whether any of that was necessary. And those are going to be complicated issues. I don't think much is going to happen. I don't think the federal government's going to prosecute any of the agents involved. I don't know what's going to happen with regard to these escalations moving forward. Ideally, we would come toward some sort of path forward in this country where there's consensus on immigration enforcement.
Is part of this the pressure on ICE agents to increase arrests to something like 3,000 a day, up from roughly 660 a day?
We're in month 6 now of this administration. I think in months 1, 2, and 3, where there was this discussion about really focusing on criminal backgrounds first, that was happening. And yes, there might be some people who were protesting, but those people were really on the fringes, because it's really hard to argue against deporting people with criminal convictions. But I do think there needs to be some discussion about this. And I even think the president, to his credit, actually said that when he said in a press conference this week that he was concerned that enforcement might be affecting the farms and the hospitality industry. And so there might be some opportunity here to provide some guidance. And what I've heard from people in this sphere who are more reasonable is, look, people with criminal backgrounds and people who came in the last 4 years during the period where there was this open border policy of people coming through the border at hundreds of thousands a month, that should be the focus. And then if you're sort of here before 2020, maybe you wouldn't be a focus of the immigration enforcement. Something like that, I think, would lower the tensions here while still giving plenty of work that can occupy this administration for the rest of the 4 years.
Yeah, on Thursday, Trump did seem to be softening his stance on undocumented farm workers and hospitality workers.
Our farmers are being hurt badly by, they have very good workers. They've worked for them for 20 years. They're not citizens, but they've turned out to be, great. And we're going to have to do something about that.
I mean, is there a way to carve out certain migrants who work on farms or in the hospitality industry?
That might be unseemly to write it exactly like that, but there have been prosecutorial discretion memos, both under the Obama administration and the Biden administration. And in fact, there's a Supreme Court case where the state of Texas challenged the Biden administration prosecutorial discretion memo, and the Supreme Court said that's none of your business, state of Texas. The Biden administration can have a prosecutorial discretion memo. So to the extent that President Trump wants DHS to have such a prosecutorial discretion memo, yes, it could say we're going to not focus on the farms and the hospitality industry. But I think probably what would be well advised is, rather than just those very narrow carve-outs, I think it's about a larger sort of way to diffuse tensions. And I think that would probably be a memo that said, yes, you can pick industries that you're concerned about. But I think, again, there's plenty of people for ICE to put through the process if you were limiting it to criminal non-citizens and also people who've arrived during the Biden administration, let's say. That's still millions of people. You will not get to all of those people if that's what you focus on. And you don't have to say, well, we won't 100% go after other people, but you can say those folks will be deprioritized and will not be the subjects of any affirmative operations. And I think that would do a lot toward diffusing a lot of this tension, but still giving, like I said, plenty of work for the Trump administration to do with regard to removal.
Leon, I want to talk for a moment about the case of Mahmoud Khalil, who was a leader in the pro-Palestinian protests at Columbia and the first person arrested in the Trump crackdown on student activism.
There are two grounds for trying to deport him. The most important ground, the court said, is this statute which says that if the Secretary of State finds that your conduct would be detrimental to the United States foreign policy, they can order your deportation. And what the court found was that this provision is constitutionally void because it's too vague. The vagueness doctrine means that when you pass a law, nobody knows how to implement the law in a way where they can follow it. So suppose the Congress passed a law that said you can't be out too late at night. What would that mean? You wouldn't know what too late at night meant. Would it mean 8 p.m.? Would it mean 9 p.m.? Would it mean 10 p.m.? And so that would be void for vagueness. No one would know. And it's the same concept here. How do you know what speech you can make that's going to make you subject to a policy that says that you can be deported for violating the foreign policy interests of the United States? And so unless there's clearer guidance given, that's a too vague statute. Now, the problem is there's two other big arguments that the government has. They're saying that they're also trying to deport him because he lied on his green card application, because he didn't disclose that he had worked for the Syria office and the British Embassy in Beirut. Also, he didn't disclose that he worked at the United Nations Relief and Works Agency for the Palestinian refugees. And he also didn't disclose he was a member of the Columbia University Apartheid Divest Group. And so all of these things would have been informative in his green card application, and the fact that he didn't disclose those leads him to also be deportable on that. And so that's one argument. And the second argument is whether this habeas petition that was filed by Mr. Khalil is actually the right forum to make any of these arguments, or whether he can only make it in the removal process so that it would be at the end, if he's ordered deported, only then could he make his argument. That's also a very strong argument that the government has. And so we're going to have to see both of those before we see if Mr. Khalil ultimately gets freed from detention.
So a New Jersey judge had ruled that the government couldn't continue to hold him on that first ground, the foreign policy ground. But on Friday, the government submitted papers saying that it could continue to hold him on the second ground, that he'd lied on his green card application. So the judge refused to order his release, saying he hadn't presented enough evidence that detention on those grounds was unlawful. Is lying on your green card application enough to get you deported?
I mean, it can, because given that he's not a citizen, he doesn't have to be denaturalized, which is a very long process that involves a federal court trial. That doesn't need to happen. So the only thing that needs to happen is he would need to be placed into removal proceedings. And then when he's placed into removal proceedings, the only thing that needs to happen there is that an immigration judge needs to agree that he lied on his green card application. And basically that's going to be an issue of materiality. And so were these three omissions material? Would they have changed something? And the only people that are going to matter there are the immigration judge, and then the Board of Immigration Appeals, which is the administrative appeal, and then maybe a court of appeals if it's ruled that this is something that the courts have jurisdiction to review. But that's it. That's the only people. So this whole other issue of the important Marco Rubio determination and that statute and everything else may end up getting shunted to the side, and the real issue that he ends up getting removed for may end up just being this application issue.
In your experience, do people often get removed for lying on their green card application?
It's usually a proxy for something more serious, just like it is here, which is they wouldn't say to you 4 years after your green card application, hey, you forgot to mention that you were in the Elks Club from November to January of 2012. They're not going to deport you for that, even though, yes, if you were a member of the Elks Club, you have to mention it. But they're not going to deport you for that. But usually what they're concerned about is if they have some reason that they want to deport you and they can show, look, this actually would have had a material impact on your application, but they can't deport you for any other reason because you haven't actually been convicted of a crime, this would be a reason that they have used in the past and could use in the future against people.
That seems like what might be happening here. Leon, thanks so much for once again taking us through the maze that is immigration law. That's Leon Fresco of Holland Knight. Coming up, Trump gets a reprieve from a court order blocking his tariffs. I'm June Grasso, and you're listening to Bloomberg. As President Donald Trump's trade war plays out in the headlines, a legal battle is playing out in the courts over his use of emergency powers to impose tariffs. Trump announced the reciprocal tariffs on imports from almost 60 countries on April 2nd.
In short, chronic trade deficits are no longer merely an economic problem. They're a national emergency that threatens our security and our very way of life. It's a very great threat to our country. And for these reasons, starting tomorrow, the United States will implement reciprocal tariffs on other nations.
Trump cited trade deficits with other countries and drug trafficking at the border as national emergencies that allowed him to invoke the International Emergency Economic Powers Act, or IEPA, to impose tariffs by executive order. At least 6 lawsuits have been filed challenging this first-time use of IEPA to impose tariffs. And the U.S. Court of International Trade ruled unanimously on May 28th that Trump had exceeded his authority and ordered the tariffs blocked. But this week, the U.S. Court of Appeals for the Federal Circuit gave Trump a reprieve, deciding that the tariffs can remain in place until it decides the case. My guest is Jimmy Gurule, a professor at Notre Dame Law School. He's a former federal prosecutor and was the Undersecretary for Enforcement at the Department of the Treasury during the George W. Bush administration. Jimmy, why did the U.S. Trade Court rule that IEPA doesn't give Trump the authority to impose these tariffs?
Well, first, it's important to understand that there are really 2 types of tariffs that are implicated in the U.S. Court of International Trade's decision. So first, there are the IEPA fentanyl migration tariffs, and these pertain specifically to China, Mexico, and Canada. And here, President Trump has declared that there is a national emergency. It's an unusual and extraordinary threat to the national security, economy, and foreign policy of the United States. And therefore, his response after making that emergency declaration is to impose tariffs against these 3 countries. The second group of tariffs are the worldwide retaliatory tariffs. And there, the unusual and extraordinary threat, the national emergency involves trade deficits. And this is much broader. It's not limited to these 3 countries, China, Mexico, and Canada, but it extends to all of the U.S. trading partners. And the claim is that, we've got this trade deficit. This is an unusual and extraordinary threat. It threatens the economy of the United States, and therefore the response is the imposition of tariffs, worldwide. And so the Court of International Trade, struck down both sets of tariffs. With respect to the fentanyl migration tariffs, the court found that there wasn't a sufficient nexus between the so-called national emergency and the importation, the abuse of fentanyl, and tariffs. So there just wasn't a sufficient nexus. Like, if the emergency is drug trafficking, drug importation, then what's the relationship between that and tariffs? And the court just said there isn't a sufficient nexus between the two, and IEPA just doesn't justify the use of tariffs in this way. So again, it's a statutory construction issue involving the interpretation of the International Emergency Economic Powers Act. With respect to the second, the worldwide retaliation tariffs, have said that the language in IEPA, which authorizes a president to regulate importation through economic sanctions, the court says does not confer unlimited tariff authority on the president, and therefore struck down that set of tariffs as well.
So the appellate court is allowing Trump to keep the tariffs in effect while it plans to hold arguments July 31st. Did it offer a reason for siding with the administration at this stage?
It didn't. In fact, if you look at the order, it's very short. I think it's 4 pages. And so it's very conclusory in nature and doesn't really spell out the reasons why. It is basically blocking the nationwide permanent injunction on the tariffs, but just said that it was warranted in this case. One could reasonably speculate that the appellate court is just concerned about the impact and the implications of the lower court decision. I mean, if the tariffs are illegal and therefore should be blocked, block pursuant to this permanent restraining order, then it's going to just, turn on its head, the Trump administration's policy, economic policy with respect to foreign affairs, commercial trade worldwide. And so I think before the court is willing to authorize this or permit action that has such far-reaching impact, that it wants to give the parties ample opportunity to fully brief and litigate the issues for the appellate court to consider.
Those challenging the tariffs may seek an emergency appeal to the Supreme Court. Has the Supreme Court ruled on IEEPA before?
Yes, there have been some Supreme Court decisions interpreting, the scope of IEEPA, but this specific issue of whether IEEPA authorizes the president to use tariffs as an economic sanction in response to the national emergency, that's an issue of first impression. And the reason being that this is the first time, the use of tariffs under IEEPA by President Trump is the first time in the history of IEEPA, which was enacted by Congress in 1977. It's the first time any president has used IEEPA to authorize the imposition of tariffs against any country, let alone every trading partner of the United States. So it's an issue of first impression.
You were Undersecretary for Enforcement at the Department of the Treasury dealing with IEEPA. What was IEEPA used for?
It was used in a dramatically different situation than it's being used today by the Trump administration. When I was Undersecretary, President George W. Bush declared an emergency with respect to foreign terrorist organizations and specifically Al-Qaeda that was responsible for the 9/11 terror attacks. And that was the national emergency that threatened national security, and IEEPA was used to block transactions between individuals that were supporting Al-Qaeda, directly or indirectly providing support to Al-Qaeda. So it blocked transactions and it authorized the freezing of any assets in the United States that were linked to Al-Qaeda or its supporters or sympathizers. There was never any attempt to impose economic sanctions against any country that, say, was providing some assistance or support to Al-Qaeda. So it was a very, very different context and situation, and tariffs never even came up as a thought for the use of IEEPA in that situation.
If he's allowed to use IEEPA in this way, how much does that broaden his authority?
Well, that's a concern, and that was one of the issues and points raised in the decision by the U.S. Court of International Trade, that this would provide the president just expansive authority to impose economic sanctions on countries. And further, the court argued that, well, wait a second, there are statutes, federal statutes that Congress has enacted that authorize the president under very limited and focused circumstances to impose tariffs on countries. And so to give the president this type of sweeping authority to use tariffs under IEEPA in this way would render those statutes a nullity. It would really undermine the purpose of those statutes. Why do we need those statutes? They would become redundant and unnecessary. And so there seems to be an inherent conflict between the president's use of IEEPA in this broad way that, again, would undermine these existing statutes that Congress has enacted for the specific purpose of the president imposing tariffs in unique, specific situations.
Yeah, and administration officials have, publicly downplayed the impact of the trade court's decision, saying that most of the tariffs can be imposed by other means. So then why didn't they impose them by other means? Is it because this is quicker?
Yeah, it's easier. So to use IEEPA in this way, it provides the president a much broader sweeping authority with respect to the imposition of tariffs. These other federal statutes are more nuanced, they're more focused, and they are more restrictive in terms of, when these tariffs can be imposed and with respect to what types of commercial transactions. And so I think that the Trump administration has attempted to avoid, the more nuanced, restrictive, kind of more difficult method or authorization for imposing tariffs under those statutes and said, why do we want to go there? We've got IEEPA, let's just use IEEPA. And IEEPA, we don't have to be concerned about, the narrow focus on specific commercial transactions. We can just impose these tariffs across the board with respect to every country that we're engaged in regulatory trade.
Do you think that the appellate court, after it hears oral arguments, will affirm the U.S. Court of International Trade's decision to block the tariffs?
I think there are some very compelling reasons for striking down the tariffs under IEEPA. And I think, again, it comes down to a very kind of basic, fundamental statutory construction question. Does IEEPA authorize these types of economic sanctions tariffs? And then at the same time, we've got these other federal statutes, so it's not as if that authority is going to be removed from the president altogether. He just has to do it the right way. So that would be an argument in favor of banning the tariffs under IEEPA. You could still do it, Trump administration. You just have to do it the right way through these other statutes that Congress has enacted that deal specifically with tariffs, rather than IEEPA, which says nothing in the statutory text whatsoever about tariffs. The word tariff is never mentioned once in IEEPA. And so I think it's a way in which there could be kind of a compromise. You can't use IEEPA for these purposes, but we're not saying that tariffs are illegal, but you just have to do it the right way through the use of these other federal statutes.
Is it time for Congress to get involved here?
Well, they could. They could, of course. We're living in a world now where there's a very divided Congress, and the Republican majority at the House is razor thin. And so there's no guarantee that if Congress decided to enact legislation to permit President Trump to do what he's doing now under IEEPA, that would be enacted, that such a legislation would pass through the House of Representatives with this very small minority that the majority Republicans have at this time.
Does this legal fight over IEEPA fit into the wave of lawsuits over Trump executive orders that test the limits of presidential authority?
We're seeing it time and time again. It's just the president pushing the boundaries of executive authority, beyond reasonable limits. He wants to accumulate as much power in the executive branch as possible, and he's looking for every opportunity to do so. And so he's taking, statutes, regulations, whatever it might be, and he's interpreting them in the broadest, kind of most unreasonable way to afford him that authority and power. And really, it's up to the courts to provide that check, on balance on that authority, because clearly, Congress has abdicated its responsibilities and is doing little or nothing on these issues.
Thanks so much for joining me, Jimmy, and sharing your insights. That's Professor Jimmy Gurule of Notre Dame Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.